Go ahead and get started. And I'd like to introduce our speaker, Mr. John Shoup. John, take it away.
Thanks, Rick, and good afternoon, everybody. As Rick mentioned in the intro, so I do run our Cleveland office at Markham, but I don't think a lot of the individuals on the call or webinar might be familiar with Markham. So I was a partner at Skoda Minotti, and in December, Skoda Minotti, that CPA firm local to us here in Cleveland, we merged into Markham. So I just wanted to kind of, if nothing else, familiarize yourself with the name, and it's probably your local Skoda Minotti team behind the presentation that's partnering with Manufacturing Works today. So Ann, I'll ask you to progress to the next slide. And what I thought I'd start with for the benefit of the group is a little bit of how we got here. So there's been a lot of legislation and a lot of IRS relief that hits the news. And if you're anything like me, I'm guessing you're getting a ton of emails from all of your service providers, your attorneys, many trade associations. And so what I thought I'd talk through first was the first kind of relief and stimulus that came through from the government was the Family First Coronavirus Response Act. The main takeaway there was, employees could get 2 weeks of paid leave if they were impacted by COVID-19, and the funding of that was done through a payroll tax credit with the July 15th payroll tax filing. So the secondary item on there is the U.S. Treasury, and I'm going to say the IRS, and I think this is a little bit of a game changer. The IRS has extended the April 15th filing date and payment date for any taxes that were due to be filed and paid on April 15th. A little bit of the upside there. It also, if you're a taxpayer that makes estimated tax payments, April 15th is also an estimated tax payment date for the 2020 tax year. That has also been postponed, and the postponement date is July 15th. So there's some additional relief. So essentially, nobody's writing a check to the government, the federal government, on on April 15th. A side note there, I didn't say Ohio yet, but the good news is Ohio is mirroring the federal rules, and the Ohio tax deadlines that were April 15th are also extended to July 15th. And those are extensions of filing payment. There is no interest or penalties, and there isn't an extension form that's required. So essentially, the governments aren't asking for money. And now the last item on here, which is what we're here to talk about today, but I wanted to give a little bit of background because everything is really flying fast, is the CARES Act, and you can see it there, the Coronavirus Aid, Relief, and Economic Security. And there's a lot of provisions in there. We're primarily going to talk about the Paycheck Protection Loan. So I'm going to ask Ann to proceed to the next slide. And so as Rick mentioned, and then as I've mentioned previously, the Paycheck Protection Loan is covered by the 7A loan guarantee of the SBA. So all they did was the CARES Act amended the Code of Federal Regulations as it relates to the SBA and the 7A loan program. So now let's get to the who's eligible, which you see on the screen. And so it's essentially made for small business. Later on in this presentation, we'll get to some of the particulars. But one of the questions that comes up, and I think it comes up because we've had the economic disaster loans by the SBA that are out there, and now these Paycheck Protection Loan. One of the things about eligibility is, do I need to be directly affected by COVID-19? And so the answer to that is no, as it relates to the Paycheck Protection Loan. And so there is some certifications that the borrower will be asking for, but it doesn't need to certify, the borrower doesn't need to certify that they've directly been impacted by the COVID-19 virus. I'll read it to you, so hang with me. But the certification is that the current economic conditions makes necessary the loan request to support the ongoing operations of the eligible recipient. So I'm not an attorney and I'm not giving legal advice today, but the way I look at that is it's unknown how my business is going to be impacted, so therefore I'm asking for the loan. So that's really the only certification. There's a couple others, but it's not an affirmative certification that my business has been impacted by COVID-19. And if you go to the next slide. So now this is probably, the first part is, well, how much can I get? And then a lot of people on the call, I'm guessing there's some familiarity with, well, the loan is forgivable, isn't it? So let's ask and talk towards the how much can I borrow? So the how much can I borrow is 2.5 times. So if we're going to use weeks, let's say it's roughly 10 weeks. It's a little bit more than that, but 2.5 times a monthly payroll amount. And that monthly payroll is either the prior year, or you can elect for it to be a component of January 1st through February 29th. But essentially it is a 2.5 times 1 month's payroll. Plus, if you do have one of those disaster loans, you can roll that disaster loan into this Paycheck Protection loan. So it can be 2.5 times payroll plus this disaster loan. But keep in mind that disaster loan isn't subject to the forgiveness. It's just there are other provisions that would make it beneficial to the borrower, but you can roll in your disaster loan. I don't know how many of the participants on the call, on the webinar, actually have the disaster loan, but it is a provision that's out there. Also, an additional consideration, and one of the questions that was that was before the predated the call today was, can I get a disaster loan and a Paycheck Protection loan? The answer is no, you can't apply for both at the same time. As I previously stated, it allows for you to roll that loan into the Paycheck Protection loan if you do have a disaster loan. But essentially, I would say if you're going down the disaster loan, I would not be looking for, I would probably change paths and go down the Paycheck Protection loan. I apologize, my stall there as I saw a chat box pop up. And the disaster loan, I don't know that it was part of the Family First Act. It was actually just the SBA coming out a couple weeks ago speaking towards these economic, the EIDL loans, the Economic Incentive Disaster Loans. And those were ones that required impact by the COVID-19 virus. So as we go on to the next slide, Ann. So now we talk about allowable uses. And so the allowable uses are more than just payroll. So I think that's an important distinction. On the one hand, the loan amount is roughly 2.5 times a month worth of payroll, but the allowable uses is broader than payroll. So as you see it here, it's interest on other mortgages, it's rent and utility payments. So the point to keep in mind with the rent and utility payments is those are for rent agreements that existed before February 15th and utility arrangements that existed before February 15th. So essentially it's nothing new, or it's not new agreements, but yes, if you're having water and electric in April, those are covered because the presumption is that your business was existing prior to February 15th, and that's what you got the loan for. So it's not paying for back rent and back utility payments. It's just saying that we had an arrangement in place prior to February 15th. I don't quite know if it's meant to be a gotcha, and maybe a gotcha is a strong word. But the one aspect here is the payroll and rent, utility payments, and the interest on other mortgages is limited to 8 weeks of spending, whereas the loan amount was 2.5 months, let's call it a little more than 10 weeks of spending. So it wouldn't surprise me that if I didn't have, there's going to be rent, or there may not be, there's definitely going to be utility payments. I don't know if there's a mathematical circumstance whereby the amount of the loan would exceed the amount of the spend, but I would just say when we're going through the application stages with your lender, which we'll get into a little bit later, just something to keep in mind, because it's not 2.5 months of a loan and 2.5 months of a spend. It's 2.5 months of a loan and then 8 weeks of a spend. So it's not quite the same number. So I just thought I'd call that out. I don't know that it's a gotcha, but I just thought it was worthwhile to call out. So as we go to the next slide, we're going to talk about some loan terms. So there's a lot of information on the screen in front of us, but I think there's some good stuff here. So the interest is not to exceed 4%. Somewhat of a good interest rate, I would say, with everything else that's going on with coronavirus and the Fed lowering the borrowing rates. Maybe 4% isn't a great rate, but we'll get into how much of a burden that would be on your organization. So I like that the borrower and lender fees are waived. I'm a big fan of the fact that personal guarantee requirements, so owners are not going to have to personally guarantee these loans. That's always a contentious point whenever any kind of loan is being originated. But I think one of the biggest items here is that third bullet point where it talks about payment deferment for at least 6 months and not more than a year. So as you recall, when we were talking about the loan amount previously, we spoke towards we could roll in a previous disaster loan as well as payroll. Well, the disaster loan was requiring service, meaning at least interest payments. Well, if it's rolled into this Paycheck Protection loan, it would benefit from the 6-month deferral. So the way I look at this is if a business owner obtains a loan that's through the Paycheck Protection Program, they won't need to pay interest for 6 months. They won't need to pay principal for 6 months. During that 6-month period, they may also get that loan forgiven. I think that would be ideal. So therefore, there is no payments of principal or interest during that period. But then correspondingly, if you had a prior loan, that would also be a prior disaster loan that would be rolled into this program. You wouldn't have to pay the principal or interest on that as well. So I look at that and I say, okay, well, there's no cash burden on the individual business right now to service that loan. And then now we're going to the next 2 slides. The next one up will progress and is this sources of capital. And so this is, as we were trying to set this up quickly, we wanted to respond to the membership base that has questions, that wanted to know more about what is, the CARES Act, how it can impact their business. It would have been wonderful if I had a banker on here with me, but the banks just don't know the rules yet. So the SBA hasn't published the rules. So the how-to, unfortunately, is a little bit of a guessing game. But what's on the slide here is the SBA has delegated the authority to approve the loans to the bank. So I don't know that it's formally a credit decision like any other loan, but essentially that the way the law is written, it would lead you to believe that the bank is the one that's making the decision to disperse the loans. And then the bank as collateral essentially has the SBA's 7A guarantee, and that's why it's codified under the 7A loan program. So again, you can see how the banker's phone should be ringing by all of the respondents on the phone or on the call in the webinar, because I believe they're going to be the source of the funding, but there isn't the how-to, that doesn't exist yet. And correspondingly, we weren't able to get a banker to join us today. So if we go to the next slide, Ann. So we have these considerations for approval. So this essentially is speaking towards a little bit towards loan eligibility. So what we have in here is we have that the business had to be operational on February 15th. The near middle bottom of the page, it says not more than the greater of 500 employees. So there we have our definition of a small business. So the small business is 500 or less employees. Now the caveat here, the something to know, is it's not 500 full-time equivalents as maybe we would think. It's 500 full-time, part-time, and other basis. Again, not an attorney, not trying to interpret, but I look at that other basis as 1099 independent contractors also count in that 500 employees. So let's give an example. If one of the businesses on this phone call or somebody that was applying had 498 full-time employees and 2 part-time employees and 1 independent contractor, putting that at 501, they would not be eligible for the loan. So essentially it's 500 full-time, part-time, or independent contractors. The business was in operation on February 15th, and it had employees at that time. So your business is not nullified from participating in this program if you have laid off employees after that. It's just a matter of the February 15th deadline date is we were a business and we had employees at that point in time. There are other, as you see on the slide, there are other carve-outs for other industries, specifically restaurants. And those carve-outs are trying to address the multi-location aspect of, we can have a business that has more than 500 employees. There's certain there's certain aspects there whereby they can be included in this program as well. My hope is that most on the call, maybe being the small business community of the greater Cleveland, Ohio area and the Akron area, we're probably the vast majority of these businesses are under this 500 or less. But there is some additional relief if your business is greater than, but it didn't, as I looked at it, it didn't look like it was providing relief to manufacturers that were greater than 500. So now let's go to the next slide, where we talk about some of this eligibility for loan forgiveness, because this primarily, I look at it as the game changer. This is why if I'm a business owner, I'm not looking at the disaster loan through the SBA, through that 7A pro. I'm not interested in that because that loan's not forgiven. This can be. So, so as we look at this eligibility for loan forgiveness, you can see those eligible costs, again, those payroll cost, interest payment, payment of rent, and utility. And again, that speaks towards these things that existed prior to February 15th. One of the questions that came up was this excluding compensation over $100,000. So that doesn't mean that if an employee makes over $100,000, all of their wages are excluded. It just means that if an employee is making more than $100,000, only the first $100,000 is included in both the loan forgiveness as well as the loan eligibility. So it's on both sides of this equation. As you'll see in that very first bullet point, it mentions that 8-week period. Again, that's not entirely congruent with a 2.5 month on the loan amount. So it's just something to keep in mind. We've had a couple questions come in that speak towards, well, do I need to bring employees back, or what if I was going to use this downturn as somewhat of an opportunity for reduction in force? So looking at that second bullet point there, if an organization reduces their payroll by greater than 25% during the covered period, that portion, or if an organization does that at 26%, essentially there's a portion of the loan that is not forgiven. So I'm not trying to have business owners play the game here, but if they were making a business decision to reduce headcount as part of this, hopefully that's not the case, but if it is, there is a little bit of a catch that you can't reduce the employee headcount that much, and that's that 25%. Also, the secondary point here is the principal, as I read it, the principal of the loan is forgiven, but the interest of the loan is not forgiven. Now, the principal and the interest are both deferred, but I believe, and again, this might be subject to interpretation, the rules may change, but I believe as I read it, only the principal portion of the loan is deferred. So yes, your organization would be out the roughly 4% as an annual rate on the amount borrowed for the amount of time from the loan origination to the forgiveness. So there would be some cash burn, but the 4% of the total payroll versus the support of having the dollars to fund the payroll, I think is a drastically different answer. Now, I'd be remiss as a CPA to not briefly bring in tax here, so I'm going to bring it into this. So, back in the 08-09 kind of economic downturn, there was plenty of people that maybe had gone upside down and walked away from their homes. And the banks would issue them what was known as a 1099 COD. And that COD was cancellation of debt. It was income to the individual. So they would have to report that income on their tax return. So another benefit here is with the CARES Act. The CARES Act is not including this loan forgiveness as income to the organization. So I'm going to say that again. It is not income to the organization, unlike 10 years ago with the 1099 COD of mortgage indebtedness. So on the one hand, I'm getting money that I don't have to service in principal immediately. I don't have to service in interest. I'm getting a pretty favorable interest rate. The credit determination doesn't look like it's a lot of documentation, but that's to be continued. The loan can go away in principal, and it's not included as taxable income on my tax return. there's a lot of wins there, and I don't mean to sound like I'm very dewy-eyed or naive, but those are some big provisions that would help solidify this as the game changer that it appears to be on the surface. So that's why I wanted to call out that that the amounts would be excluded from taxable income, because that's a big deal. Go ahead to the next slide, Ian. And based on this pace, we're probably gonna have a lot of time for questions. So let's briefly talk about these filing requirements. And so again, we'd benefit if there was a banker on the call, because the filing requirements are talking about both kind of the loan origination as well as the certification for loan forgiveness. So in looking at that documentation needed, so there's the number of full-time employees and their pay rates. Okay, so that's going to work towards, I was a business that has less than 500 employees and I was operational at February 15th. The IRS payroll tax filings, your quarterly filings of 941s and your annual filing of your unemployment of 940 is again going to be used as I have employees. And again, we would use these numbers to determine the loan amount. Obviously the state income as well. And then I believe these canceled checks to be more of the, I now want to get my loan forgiven. Therefore, I want to show the bank that I've used it for allowable reasons and allowable uses. So I don't anticipate that they would need canceled checks to pay the payroll on the application stages. But again, not a banker, don't know the rules. It was just part of the documentation. So the next bullet talks about these certifications, but before we get to these certifications, as I look at the documentation needed, again, the banks will ultimately determine this, but as I look at the documentation needed, I don't see owner's tax return. I don't see financial statements of the business. I don't see lien searches to see what the other collateral is. I don't see personal financial statements. I literally just see business with employees, give me money. And I know I was a little bit, sophomorish with my words there, but it's what I don't see that is really exciting, because it doesn't look like a normal credit determination by the bank. So again, now these certifications, there's actually 4 certifications in the law. It's the documentation is true and correct. Obviously, you use the funds for what were allowable expenses. And then here it is, that certification that I talked about on slide number 4, where again, the borrower must certify that the current economic conditions makes necessary the loan request to support ongoing operations of the eligible recipient. So again, it's not saying I affirmatively have COVID-19 exposure. It just says, I don't know where the world's going to end up, and that's why I'm certifying, I'm asking for this loan. So I don't know if that would make certain borrowers uncomfortable on the call, but there is an affirmative certification to that end, so I thought it was worthwhile to call out. So now we're going to go to the next slide, and this is the one that I wish I had better answers, and we are really cooking with gas on our pace here. So to apply, when we were initially drafting this, the SBA had a kind of a lender portal that you could click through, and it would maybe give you applicable lenders in your jurisdiction, in your locale. So in clicking that this morning at about 10 o'clock, it actually took you to this Paycheck Protection Program. So the online referral tool is now taking you to a landing page for this Paycheck Protection Program, but it doesn't have a link to follow you through to your actual lender. So it's still in a state of flux. So what's the ask here? So I would start placing calls to your existing bank and financial institution, because as I was saying previously, that existing bank and financial institution has been delegated the authority to make the loans, and if there is any kind of credit decision, they'll be making the credit decision. So I would say if you have deposit accounts, or you have a line of credit, or you have term debt with an existing bank, that to me would be the first call that I would be making rather than the SBA. So that's why I'm kind of coaching you towards talking with your existing banker. And as you'd imagine, it would make perfect sense if we had a banker on this call with me so they could lend some color to that. So in the 3 bank conversations that I had today and over the weekend, the banks are hopeful that they will have some guidance and maybe applications by the end of this week. I don't know that crossing our fingers and hoping is going to get it done, but I thought for the benefit of this call and this webinar, I would provide some context of anecdotal feedback that I have from certain bankers. But again, that's state of flux because everybody right now would want to know, okay, how do I get it done? And where do I apply? So from the presentation perspective, if we progress to the last slide, you're going to get my picture and my contact information. I can see that we've got 7 chat boxes, and I also have some questions that were submitted previous. I thought before we got to the chat box, I might offer up the questions that were submitted to me previously and offer up some feedback. And then I might bring in Rick or Ann to facilitate the chat box or other questions that Ann got. And then we can try to work through those Q&A because we have this tremendous amount of time for Q&A, and I'll try my best to answer what I have. So before I turn it over to Ann and to Rick, I thought I would offer up some of the questions that came through prior to the call. And so one of the questions that came through prior to the call is there anything that would disqualify a small business from the program? Specifically, would credit, past bankruptcy, or past default on a loan prevent us from receiving it? So again, I believe the lenders are the ones making the credit decision. So it's a little bit of a don't know, but if you look at the documentation requirements in the law and you look at what the lenders are asking for in that documentation, it doesn't look like it's a credit determination. It looks like it's 500 employees, was in business on February 15th, had employees on February 15th, had eligible payroll, and here's what I'm asking for. So again, the bank will make the determination, but the way I read it, it doesn't look like a past bad actor, if you will, from a credit decision is going to impact this credit determination. So another question that came out is, if we lay people off, should we immediately rehire them? And does this affect our loan forgiveness? So the immediate rehire, I would say, doesn't need to happen. So the loan forgiveness rules target 2 windows to measure for the baseline for the monthly payroll. So this is trying to get my loans and what is the measurement period, and then what will I be measured against? And measured against is either February 15th of 2019 to June 30th of 2019, or January 1st of 2020 to February 29th of 2020. So it's trying to say, these are my baseline payroll. So based on that, that's establishing the baseline. So taking it one step further, the measurement period, though, for the cover period for that 8 weeks is from the loan origination date, so when the loan is dispersed, to the 8-month period after that. So if I was looking to rehire employees that I furloughed or laid off, I would be looking to bring them back right around the time that I'm getting the loan funding, or maybe slightly before, just to make sure I've got my documentation and ducks in a row. But I'm going to be looking at that target date as the one where I'm going to bring my employees back. And then the last question that was submitted on the pre-call, if you will, was, we now have people who are earning more money sitting at home. And so what happens if I recall an employee and they decide that they'd rather stay home? Are they now removed from this unemployment? And this goes to those, the $600 of additional unemployment. We may find that some employees are actually making more money sitting at home than actually working. So here's a little bit of the challenge, right? So there's a business decision here. And the business decision is of the business owner or anyone that's making these hiring decisions of, okay, are my employees coming back? Do I want to bring them back? And will I need them for when I ultimately restart if I've furloughed, or what do I want to do with my employees? There is a stipulation that they can't be double dipping. So the purpose of this Paycheck Protection is to bring employees back on payroll. It doesn't say bring them back to work, but it just says bring them back on payroll. So therefore, if I'm bringing them back on payroll, they're not on unemployment. Therefore, they're not eligible to get that extra $600. And yes, they could conceivably not like that economically as much as sitting at home and getting this extra $600. It's a at-will state in Ohio. And therefore, if employees decided to not come back to work, the organization would probably be looking at this 25% safe harbor, that if the payroll is lower by 25%, you can still have the full loan forgiven. But yes, that there is a takeaway that they can't double dip. They can't be unemployed, collecting unemployment, and also be subject to this Paycheck Protection Loan. So I see there's 12 questions in the chat box. I was trying to not look at them as I was going through the presentation. That was all I had from the pre-questions submitted. So I don't know if Rick or Ann, how we want to do the chat box. If it's me opening up and just reading them to the group, I'll pause and let Rick jump in if he had feedback.
Sure. So actually, I do have a few other questions that were submitted ahead of time. So let's go ahead and cover these first. And then I would say, let's go to the chat box. And then in the meantime, if you have other questions that you want answered, by all means, go ahead and type them in and we will get to them. It looks like we've got time. So one question here, it says, our company wanted to know if we can apply for both the disaster relief loan and the CARES Act loan, or are they mutually exclusive? And I know you did talk about that earlier, but I just want to make sure that it was reiterated.
Yeah, so they are mutually exclusive from an application perspective, meaning if you already have a disaster loan that has been funded, it can be rolled into the Paycheck Protection, but you cannot apply for both loans at the same time. It's one or the other. And again, I'm not an attorney and I may not be your accountant, but I would say the Paycheck Protection Loan with loan forgiveness looks better than the 30-year disaster loan.
Thank you, John. And then we have a question here. It says, how will the qualified small employer health reimbursement reimbursement payments can be classified for this program?
Yeah, so I believe there's additional relief that those, I'm trying to think, the health and benefits aspect, and this gets a little bit down deep in the law, the health and benefits aspect is a part of the covered expenses to be remitted. And I'm trying to think if those qualifying plans, that one I might need to follow up on, because that's a very narrow sliver of what could be eligible. I believe it to be eligible, but I can put that on the follow-up list and we can get a message back out to that individual.
Yep, that'd be great. He did follow it up with a different question in regards to that. Will those payments be considered as health care and included in the calculation for loan limitations? Do you know?
They would be. They would be included, but they're not part of that $100,000 limitation. That's just salary, but they would be considered and a part of the loan for use of proceeds as well as forgiveness. That's how I understand it. And
do they know how applications will be prioritized?
You know, so I think that's a great question for your bank. So let me give anecdotal feedback. Right now, we don't know. But when I was talking with one of the bankers earlier, and I'm not trying to say that a client is more important than a prospect, but I would imagine that if you are an existing bank customer, you will get priority over a prospect or someone that is not an existing bank customer. So I believe it's going to be run first come, first serve, or FIFO if we want to do an inventory term for the manufacturers on here. But I would say using your existing lender or financial institution is going to get it done faster than calling a bank that you don't do business with.
Great. And I should just let everyone know too that hopefully later this week, as soon as the banks let us know for sure that they have their content ready to go, we have been in talks with a few different banks about getting a follow-up call for all of you so that you will have a banker on the line here that would be able to answer these questions for you. We tried with 3 different banks. We tried with 3, and I know John did as well. They are just scrambling right now to try to make sense of all of this and get their processes ready to go. So, you know, please stay tuned, but we will get these questions answered for you. Finally, from this individual, it says, is there any talk of additional funds being authorized after the initial $349 billion is exhausted?
You know, that's a popular question that comes up, because if we did the quick math, I think that $349 billion disappears in a day. And so there is authority to amend that. It doesn't look as though the law provides that authority, but I would fully anticipate that if the $349 billion was kind of sucked up, for lack of a better term, that extra relief would be provided. And I know it's anecdotal feedback, but I saw that the House was talking about stimulus 4. Right now they would say the CARES Act is stimulus 3. Who knows? It's not really worthwhile to speculate, but if that would have additional funding. But currently written in the law, it says up to $349 billion. My expectation is they would expand that. And now this is me being a little bit edgy, but that if they're already printing money anyways, why not print some more money? So I kind of answered it with a hope and a prayer, but I would anticipate that they would stand ready to issue more than the $349 billion.
And John, do you know if a company is in a tax repayment plan, if that would be a disqualifier?
It is not a disqualifier, as I know it. And also the IRS relief with levies, offers in compromise, some of the IRS relief, either the 2020-18 or maybe a later number. The IRS is actually offering relief to those companies as well to kind of put a stop on servicing that offer in compromise or the loan they have with the IRS to settle a past debt. So it doesn't look like it comes into the credit determination here. And it looks like the IRS, on the other hand, is being nice with their existing levies and offers in compromise. So my expectation is that it would not preclude a borrower.
Great. And then we have one final question that was submitted beforehand. The person says here, info on our bank's website mentioned before February 15th an 8-week period. Can we use a PPPL for current utility bills? To cut payroll, we are going to a 30-hour work week. Is this allowed for this loan?
So what is it? Oh, payroll protection loan. Okay, the PPPL. So Rick, do you mind reading? I got hung up on what the PPPL meant. I apologize.
Sure.
Do you mind rereading that one more time for the room and myself?
Absolutely. So information on their bank's website mentioned before February 15th and an 8-week period. So they just wondered, I guess, can they use their current utility bills for this loan? So that was question one, and it was a 2-part question. Go ahead and answer that.
Yeah, so keep in mind that the loan amount, so how much could I get, is calculated off of payroll, and it's 2.5 times a monthly payroll, and that's prior year, 2019 payroll. So on the one hand, I have to get the money to then spend the money. So to get the money, it is based off of the 2019, or at an election, you could do the 8-week period of 1/1 to 2/29 to try to determine how much loan proceeds you're available to receive. Loan proceeds can be spent on utilities. The expectation is that those utilities were existing prior to 2/15 and continue to exist now because they would be a future expense because the money hasn't been funded. And then I think there was a part of that statement, Rick, that talked about reducing to a 30-hour work week.
Yes. So she said, in order to cut payroll, we are going to a 30-hour work week. Is this allowed for this loan?
Right. So keep in mind that cutting to a 30-hour work week, if I do my rough close to not having the full amount forgiven, it doesn't preclude you, the business, from obtaining the loan. It's more a preclusion from, can the loan be forgiven? And that forgiveness is at that 25% metric. So I would say doing a 30-hour work week would not be a problem. Just know that there's the risk that not all of the loan would be forgiven.
Great. Thank you, John. So yeah, I would say at this point, if you wanted to go back on the chat box and start addressing some of these questions, that would be great.
Yeah, so how do I turn on audio? Hopefully, David, we got that figured out.
Yeah, we were addressing that to him earlier.
You know, and to be fair, I'll admit this. I didn't come to this presentation with knowing which bill or act the disaster loan was part of. I don't know that it's Families First. I don't know if that it was part of a Treasury edict. So I don't know which it was, but I will tell you it's probably been out there for 10 days prior to the Paycheck Protection Loan. So it's not as though, and this was an expansion of the disaster loans. So the EIDL loans, as they're known, those economic incentive disaster loans, that has been part of the SBA regulations well before coronavirus and COVID-19. So what it did was it expanded, kind of the use of that loan program. It changed the terms to maybe have a 30-year repayment date, and it made the application more simplified. So the first volley into getting cash to businesses was this economic disaster loan, and those rules probably changed to expand it about 2 weeks ago, but the disaster loan itself already existed. So I can't tell you what law changed the expansion, but I will tell you the disaster loans already existed as a convention of the SBA's 7A loan program. Next question, is the CARES Act of 2020 finalized? Can it change after April 1st? It would take an act of Congress, Senate, and the president to change it. The president did sign the law last Friday, the 27th, about 4 o'clock. So it is law, it is finalized. So now it's more or less, okay, how does this get administered is what's in front. It's what's in front of essentially the banks and the lenders. So next question, I thought the loans were forgiven. The loans will and can be forgiven. Again, there's eligible proceeds as to what you use it on. And so essentially your use of funds is limited. But essentially, if on the one hand, the goal is to pay people and you're going to pay people as a business owner, the loan should be forgiven. Again, the principal portion of the loan, as I read it, I think the borrower is still on the hook for the interest. So the next question from Ron is, if borrower and lender fees are waived, how do the banks and financial institutions benefit from these arrangements? Very good question. It's almost an economic disincentive for them to answer your call to issue these loans, because there is a theory, no money in it for them. Now, on the flip side of this, they are still getting the interest, although deferred. So there's a small upside there. And the banks themselves are going to be made whole through the SBA 7A loan program. So essentially the collateral for it is the full faith and backing of the federal government. So the banks will be made whole. But you're right, there's not a lot of economic incentive other than being a good steward, if you will, because there's no extra money in it from them. That's why I'm almost saying call your existing financial institution, because there is almost an economic disincentive. There's no money in it other than that 4% of interest. When we apply for the 7A loan, is the date we are using February 15th or the date that we are applying? So I would say the date you're using for the application would be a current date. The measurement date for loan proceeds and eligibility would be before February 15th, because essentially what it's trying to get at is it's trying to say, if on February 29th you laid off your employees, you're still eligible, because essentially the government and the stay-at-home orders and all that kind of edicts that came down were after February 15th. So the application date would be a current application. The funding would be a current funding, but a lot of the metrics for loan eligibility are February 15th and prior. Scrolling down, with the 100K cap for compensation, is this prorated? So I may have answered this, I may not have. $100,000 is what each individual employee is limited to. So for those that make $200,000, make that math easy, $175,000 on an annual basis, only $100,000 of their payroll is subject to the loan approval and the loan forgiveness. So one of the tricks here is, okay, but if I'm paying an individual that's getting an annual run rate of $175,000 in their payroll, there would be a component of that pay that would not be subject to the forgiveness. I don't know how they're going to work the mechanics out, but essentially that one individual employee could be receiving payroll for amounts in excess of what is forgiven. But on the flip side, the borrower wasn't given those dollars on the front end as eligibility, so they weren't funded. But essentially, yes, the company would have an additional burden. If people are making over $100,000, the government is not providing relief on that amount over $100,000. Next question, Scott Shaver. The total loan can include health insurance benefits. It can to pay them. It is not part of the calculation of the funding, but it can include health insurance and benefits. That's part of the uses of funds that's allowable. Adam Knowles, can you clarify if a disaster loan, if rolled into a Paycheck Protection 7A loan, the 7A loan is no longer eligible for forgiveness? So that's correct. So the 7A loan, or the, I'm going to call it the disaster loan. So let me be very clear here. If a disaster loan is rolled into the Paycheck Protection, that disaster loan will not be forgiven, okay? But that disaster loan will benefit from the deferment of payment of principal and interest for at least 6 months. So the loan will not need to be serviced for 6 months, but it will not be forgiven. It will exist when the organization comes out the other end and the 7A guarantee provided to the existing bank satisfies that payroll piece. So yes, a disaster loan that exists today rolled into a Paycheck Protection loan will exist after, and it is not forgiven. So we had a couple questions. If I had 2 banks, you know, would I apply to both, or should I pick one? I would leverage that kind of question as whoever you have a better relationship with, meaning who you think is going to act quicker, who you think is going to answer your call, who you think is going to collaborate with you, is probably a better source. So I would say effectively pick the bank that works better with you. And then essentially the question has come up is pass-through income in an S Corp. Does that part of the payroll calculation? And the answer is it is not. It's a W-2 type metric, so it is a wages metric. So S Corp earnings are not part of the payroll calculation for loan funds, and they are also not part of the, to pay them out, they're not essentially eligible uses of funds. So I will, on that point, I'll pause for a minute, because we all sit here and we know that cash is fungible. So if you get money and you put it in a bank account and there's other money that was already there and that organization uses that cash to pay an expenditure, well, was that the dollar that was there, or is that the new dollar? So I'm not advocating that everybody run out and create a new bank account, but I would acknowledge that there are other costs that are being serviced by the organization that's still operational. So to the extent you can separate dollars and maybe set up a separate account for this Paycheck Protection loan, maybe it makes your life easier as the kind of the certification and the proof stages, because as we all know, cash is fungible. But to answer the question asked, S Corp earnings are not part of the payroll loan nor part of the forgiveness. Regarding the baseline calculation for monthly payroll amount, what portion of medical costs can be included? Employer portion of medical expenses only, or employer or employee contribution? So there's an additional carve out in the CARES Act that is providing relief for the employer portions of the employer portions of payroll taxes. I'm sorry, and essentially FICA and Medicare. So that portion of the CARES Act is mutually exclusive from payroll, from the Paycheck Protection. The only reason of saying that is they're making a specific call out that says you can't apply for Medicare relief on the employer portion and get the Paycheck Protection. That's not the question being asked, but essentially it is an important distinction that says there's additional relief, which we did not talk about, for an organization that wanted the employer portion of the Medicare and payroll taxes. Adam, to be specific, I don't know in the law if it specifically addresses the employer portion. I'd also like, if I could, to follow up with you rather than guess on the call today. This is me hedging a little bit of I don't know what I don't know, and I'd rather not misspeak. So what we can do is, maybe for the benefit of Adam and the group, we could get an email back out through Manufacturing Works as to answering that question. I would have definitely imagined the employee portion. I'm not sure on the employer portion, so I'd like to punt if I could. Next question, can you reiterate the payroll dates of information we should be collecting for the loan process? So the loan payroll dates. On the one hand, I have seen February 15, 2019 through June 30th, 2019, essentially the same period they're looking at for the current year, 2020, but for the prior year. And I was trying to pull up in the Act right now if it was the full annual period or if it was just that 3.5-month period. Or the borrower can elect to be measured on the January 1st, 2020 through February 29th, 2020 as a secondary option. My takeaway here is I would want to get my hands on all of my quarterly payroll filings for the year of 2019. I would ready those PDFs to have them. I don't know that since it's not April, I don't know that there's been a current 941 payroll tax form filed yet for any corporation. So if I'm essentially getting ready, and so again, what this leads to is the loan determination and the borrowing limits that the bank's going to give. The ask is better placed to the bank, but as I look at it, I would get my hands on all of my 2019 payroll tax forms and have those ready. As I was reading some of the measurement periods, it looks as though February 15th of 2019 through June 30th of 2019 were some magical dates, but there's also some reading in the law that speaks towards the annual payroll of the prior period, annual monthly payroll times 2.5%. So it's a little unclear. So I guess the way I would look at it is just ready to have the payroll tax forms for all of 2019, both unemployment and payroll tax forms at your fingertips, and then the bank will guide you through what is actually the requirement to have on hand to get to the actual loan. So as I look at here, I just pulled it up, the law. It says the average total monthly payments by the applicant for the payroll costs incurred during the 1-year period before the date on which the loan is made. So, or you can elect an additional period. So I would get my hands on all prior year 941s for the benefit of, which is the quarterly payroll tax filing. But again, that's going to be driven by the bank as what they would ask for in a loan approval. A few more here. I think we got a couple more minutes. So today I heard from ADP that if we ask an employee back to work and they decline, they will become ineligible for unemployment. I don't know that I can speak to that. So I'm going to kind of defer to the guidance, Kelly, that you may have gotten from that. On the one hand, as we talked about, getting them off unemployment is somewhat of a mutually exclusive condition to bringing them back to work. I'm not advocating paying an employee that doesn't intend to come back to work, but maybe therefore they aren't part of the amount of the loan we're asking for. So if employee XYZ is not intending to come back to work, it might make them ineligible for unemployment or still eligible. That I don't know. But effectively, the intent is for the Paycheck Protection to pay those employees that I intend to pay, ultimately trying to bring them back into the payroll and off of the unemployment. Is another question: if there is more money applied than what the government signed into law, will they be determined who gets the loan forgiven? Great question, right? That falls into the unknown category. That was also one of the questions I think previously submitted, or a derivative of that question was previously submitted to Rick. If the loan amounts are given in excess of the 349, will those still be forgiven? Can they give loans in excess of the 349 billion? Somewhat of an unknown. My hope is that if they're going to extend the loan greater than the 349 billion, they would also extend the loan forgiveness. But again, that mechanism isn't built into the existing law. So what does that mean? I'd want to be first in line. I wouldn't want to be last in line. And then last question I have here: aren't the banks incented with a 5%, 3%, and 1% fee and the balance of the loan and the disbursement of the covered loan? You're right. The question that came in on the incentivized, there's a somewhat economic disincentive because there is no fees. The fees are waived. The only economic incentive for them is they get the interest, maybe up to 4% of the loan in front of us. So I can't imagine the banks aren't going to be good corporate citizens. I truly believe they will act in good faith, but you're right, there doesn't appear to be an incentive of the loan.
Okay, well, I believe that is it for all the questions that we have. So with that, thank you everyone for joining us on the call today. Thanks to John for sharing such valuable information and insight during these trying times. We encourage all of you to share with us your thoughts on topics you'd like covered in future calls like this, and we'll do our best to address them for you. Please stay tuned to your email as we announce our next call. And if there are other manufacturers in your network you think would benefit from this information, feel free to share this with them or let us know, and we'd be happy to reach out to them. As I mentioned earlier, an archived version of this call will be available on our YouTube channel, and the link to our channel can be found at the bottom of the Manufacturing Works website. Thanks again, stay safe, and we look forward to speaking with everyone soon. Goodbye.